Frequently asked questions. Key information about the Industrial Relations Central Rules 2020. What are the Industrial Relations Central Rules 2020? These comprehensive rules, proposed by the Ministry of Labor and Employment, establish a framework governing employer-worker-union relationships. They provide clear guidelines for resolving industrial disputes, implementing standing orders, and recognizing trade unions within establishments. Why is the government implementing these rules? The government aims to modernize the regulatory framework by replacing outdated workplace regulations with a streamlined system under the Industrial Relations Code 2020. This initiative seeks to simplify compliance requirements for businesses while safeguarding workers' rights in today's evolving economic landscape. Who has the authority to create these rules? The central government is developing these rules under powers conferred by Section 99 of the Industrial Relations Code and Section 24 of the General Clauses Act. The Ministry of Labor and Employment serves as the primary administrative body overseeing their development and implementation. What is the current status of these rules? The rules remain in draft form, with the government having issued a notification of their proposal. Before finalization and implementation, the draft will undergo a thorough public consultation process to incorporate stakeholder feedback. How will these rules impact workers and employers? These rules will establish new standards for dispute resolution, union operations, and employer-worker interactions. They are designed to foster a more collaborative industrial relations environment, enhance transparency, and reduce unnecessary litigation while balancing the interests of all parties. What establishments do these rules cover? These rules apply to all industrial establishments under central government jurisdiction, addressing working conditions, service regulations, disciplinary procedures, grievance mechanisms, and collective bargaining processes across sectors including railways, banking, and mining. What improvements do these rules offer over previous regulations? The new framework consolidates and modernizes provisions previously scattered across multiple decades-old legislations. Key improvements include streamlined procedures, defined timelines for dispute resolution, and digital compliance mechanisms that reduce administrative burden. How can the public contribute to these rules? During the consultation period, stakeholders including employers, workers, trade unions, and labor law experts can submit objections and suggestions regarding the draft rules. All constructive feedback will be evaluated and potentially incorporated before the rules are finalized. Frequently asked questions. Key information about the Industrial Relations Central Rules 2020 implementation. Which existing regulations will the new rules replace? The Industrial Relations Central Rules will supersede multiple outdated regulations including the Industrial Tribunal Procedure Rules, 1949, Industrial Tribunal Central Procedure Rules, 1954, Industrial Dispute Central Rules, 1957, and Industrial Employment Standing Orders Rules, 1946. These regulations have remained largely unchanged for over 6 decades and no longer address contemporary workplace dynamics. How long will the public have to provide feedback? The public consultation period extends for 30 days from the publication date in the official gazette. During this window, all stakeholders including workers, employers, trade unions, and industry associations are invited to submit their insights and recommendations. What is the process after public consultation concludes? Following the 30-day consultation period, the Ministry of Labor and Employment will thoroughly analyze all received objections and suggestions. Substantive feedback will be incorporated into revisions of the draft before final implementation through official government channels. What motivates these regulatory changes? These reforms stem from the powers granted under Section 99 of the Industrial Relations Code 2020. They aim to modernize labor compliance frameworks, enhance business operational efficiency, and foster balanced employer-worker relationships while safeguarding the rights and interests of all parties involved. Which sectors and organizations will these rules impact? The rules will primarily affect establishments under central government jurisdiction, including railways, mining operations, banking institutions, insurance companies, and other central government enterprises, along with their employees, management, and associated trade unions. Will stakeholders receive guidance on implementing the new framework? Yes, the government has planned comprehensive awareness initiatives and training programs tailored for employers, employees, and trade union representatives to facilitate a seamless transition to the new regulatory structure once the rules are finalized and enacted. FAQs: How to submit your feedback. How should I format my feedback? Structure your submission in 3 clear sections: your personal details, name and address, the specific rule number you wish to address, and your proposed modification with supporting rationale. While there is no strict word limit, concise and focused submissions are more effective. Any supporting documentation should be included as separate attachments. When commenting on multiple regulations, please organize your feedback by rule number to facilitate efficient processing. Where do I send my feedback? Submissions can be directed to Shri Sanjeev Nanda either by post to room number 17, Shram Shakti Bhawan, Rafi Marg, New Delhi 110001, or via email to sanjeev.dom@nic.in. For email submissions, please use the subject line "Feedback on Industrial Relation Rules," your name, to ensure proper routing. When submitting physical documents, clearly mark the envelope with attention. Industrial Relation Rules feedback for expedited processing. Will my feedback be considered? Yes. The central government will thoroughly review all submissions received before the deadline. Each submission will be systematically recorded and categorized for comprehensive assessment by the designated committee. While individual responses may not be feasible due to volume, a summary of key feedback themes will be published after the consultation concludes. What is the deadline for submitting feedback? All submissions must be received within 30 days from the official publication date of the draft rules in the official gazette. Submissions received after the deadline may not influence the current revision, but could be retained for consideration in future amendments. Can I submit feedback anonymously? Anonymous submissions are accepted. However, including your name and contact information enables follow-up if your suggestions require clarification. Personal information provided will be used exclusively for consultation purposes and handled in accordance with applicable privacy regulations. Frequently asked questions about industrial relations rules. What are these rules officially called and what is their jurisdiction? These rules are formally titled the Industrial Relation Central Rules 2020. They apply throughout India and all union territories, except for those union territories that have established their own legislative bodies. When did these rules become effective? These rules came into force on the date of their publication in the official gazette. The Ministry of Labor and Employment officially notified and implemented these rules on October 29, 2020. How are important terms defined in these rules? The code specifically refers to the Industrial Relations Code 2020. Section denotes specific sections within this code. Electronically encompasses information transmitted via email, uploaded to the designated official website, or payments made through digital channels. Form indicates any of the standardized forms appended to these rules. What is the fundamental objective of these rules? These rules are designed to consolidate and amend existing laws related to trade unions, establish conditions of employment in industrial establishments, and provide frameworks for the investigation and resolution of industrial disputes. Who qualifies as an employer under these regulations? An employer is defined as any individual who employs workers in an establishment. This definition encompasses factory or establishment owners, occupiers, managers, and contractors who provide workers for the establishment. What specific rights are granted to workers under these rules? Workers are entitled to form and join trade unions, engage in collective bargaining processes, and seek resolution of industrial disputes through various mechanisms including conciliation, arbitration, or formal adjudication procedures. What mechanisms exist for resolving industrial disputes? The rules establish a multi-tiered dispute resolution system that includes direct negotiation between concerned parties, conciliation facilitated by government-appointed officers, voluntary or mandatory arbitration processes, and referral to the Industrial Tribunal, which serves as the final adjudicating authority. Written Agreement for Settlement, FAQs. Essential information about legally binding settlement agreements between employers and workers. What is a written agreement for settlement? A legally binding document that formally records mutually agreed terms between an employer and worker to resolve workplace disputes. This comprehensive agreement serves as an official record and helps prevent future conflicts by clearly documenting the commitments made by both parties. What format must the agreement follow? The agreement must be drafted using Form I as stipulated under Section 2 of the Code. All fields and sections of the form must be completed thoroughly to ensure legal validity and enforceability. Who must sign the agreement for it to be valid? Both the employer and the affected worker must provide their signatures to validate the agreement. In cases involving multiple workers or collective disputes, Duly authorized representatives may sign on behalf of the worker group. What essential information must be documented in the agreement? The agreement must include complete identification of all parties involved, a detailed description of the dispute's nature, specific terms of settlement, a clear implementation timeline, and established monitoring mechanisms for compliance. Is there a mandated deadline for completing the agreement? While the code does not impose a strict deadline, prompt completion is strongly recommended to ensure timely resolution of workplace issues and minimize disruption to operations. What are the required next steps after signing? Submit a copy of the fully executed agreement to the designated conciliation officer without delay. This mandatory step ensures official recognition, proper record keeping, and regulatory compliance. What is the duration of the agreement's validity? The agreement remains legally binding for the specific period stated within the document. If no termination date is explicitly mentioned, the agreement continues in effect until formally superseded by a subsequent agreement. Can terms of the agreement be amended after execution? Yes, modifications are permitted provided both parties explicitly consent to the changes. All amendments must be properly documented and processed following the same procedural requirements as the original agreement to maintain legal validity. Constitution of Works Committee. Frequently asked questions. How many members can be in the Works Committee? The total membership cannot exceed 20 individuals. Worker representatives must comprise at least 50% of the committee to ensure equitable representation and balanced decision-making when addressing workplace matters. Who represents the employer in the committee? The employer appoints their own representatives, typically selecting officials who are directly involved with establishment operations. These representatives should possess comprehensive knowledge of workplace procedures and sufficient authority to implement committee decisions effectively. How are worker representatives selected? When a registered trade union exists, representatives are appointed based on union membership proportions. In the absence of a registered union, workers elect their representatives through a transparent and democratic election process. Both methods must ensure diverse representation across all departments and worker categories. Who leads the committee? The committee leadership consists of 4 key positions: a chairman, appointed by the employer, a vice chairman, elected from among worker representatives, and both a secretary and joint secretary, elected annually. These officers coordinate meetings, document proceedings, and oversee the implementation of committee decisions. What qualifications must workers meet to be eligible for nomination? Workers must have completed a minimum of 6 months of continuous employment within the establishment to qualify for nomination. This requirement ensures that representatives possess sufficient workplace experience to effectively address relevant issues. Under what circumstances can representatives be removed? Representatives may be removed from the committee for specific reasons including serious misconduct, persistent inability to fulfill duties, or significant violations of committee protocols. Any removal action must adhere to established procedural guidelines to ensure fairness. How are committee vacancies filled? When a representative's position becomes vacant due to resignation, removal, or other circumstances, a replacement is selected following the same procedural framework used for initial appointments. This ensures continuous and appropriate representation throughout the committee's term. What core responsibilities does the Works Committee fulfill? The committee's primary mandate is to develop and promote measures that establish and maintain positive employer-worker relations. Key focus areas include enhancing working conditions, implementing welfare initiatives, improving productivity standards, and establishing effective dispute resolution mechanisms. Frequently asked questions. How long is the term of office for representatives? Representatives serve for a term of 2 years. Members appointed to fill casual vacancies serve only for the remainder of their predecessor's term. This approach maintains committee continuity while ensuring regular opportunities for new representation. What happens if a member misses meetings? Any member who is absent from 3 consecutive meetings without obtaining prior permission automatically forfeits their membership. This policy ensures all committee members maintain active participation and fulfill their responsibilities. The committee then follows standard procedures to fill the resulting vacancy. How often are Works Committee meetings held? The committee must meet at least once every 3 months. However, additional meetings can be convened by the chairman or upon written request from the majority of worker representatives when urgent matters require immediate attention. Who decides the meeting procedures? The committee establishes its own procedural rules during its inaugural meeting. These procedures cover meeting notifications, quorum requirements, voting protocols, and minutes documentation. All established procedures must align with relevant labor laws and regulatory guidelines. When and where are meetings usually held? Meetings are conducted during regular working hours at a venue provided by the employer. The employer is also responsible for furnishing all necessary meeting facilities, including appropriate space, documentation resources, and required equipment. Time spent by worker representatives in these meetings is counted as regular paid work hours. Can external experts attend Works Committee meetings? The committee may invite subject matter experts to specific meetings when specialized knowledge is required, subject to prior approval from the chairman. While these experts may provide valuable input and information, they do not possess voting rights within the committee. How are decisions made in the Works Committee? The committee strives to reach decisions through consensus whenever possible. When consensus cannot be achieved, matters are resolved by majority vote. The chairman holds a casting vote to break ties. All committee decisions must be formally recorded in the meeting minutes for future reference and implementation. Frequently asked questions about Grievance Redressal Committee. How many people are on the committee? The committee consists of up to 10 members with equal representation from management and workers. This balanced structure ensures fair consideration of all grievances. Who represents the management on the committee? Management representatives are appointed by the employer. Typically, these are managers who work directly with employees and have thorough knowledge of company policies and workplace practices. How are worker representatives selected? Worker representatives are nominated by the registered trade union. In the absence of a union, workers elect their representatives through a direct nomination and election process. Adequate representation of women workers is mandatory to ensure gender balance. How long do committee members serve? Committee members serve for the same duration as trade union members. Without a union, the term is 2 years, with possible extension based on performance and willingness to continue. What powers does the committee have? The committee is empowered to hear grievances, conduct investigations, request documentation, interview relevant parties, and make binding recommendations. They may also propose workplace policy improvements to prevent recurring issues. How often does the committee meet? The committee meets at least once a month to address pending grievances. The committee may convene emergency sessions for matters requiring immediate attention. What types of grievances can be brought to the committee? Employees may present grievances related to working conditions, harassment, discrimination, promotion disputes, leave conflicts, salary discrepancies, and any workplace concerns affecting their well-being or rights. Is there confidentiality in the grievance process? All grievances are handled with strict confidentiality. Committee members sign confidentiality agreements to safeguard the privacy of all involved parties throughout the process. Frequently asked questions, grievance redressal. How do I file a grievance? You can submit a formal application to the Grievance Redressal Committee. Your application should include your full name, employee ID, department, duration of employment, a detailed description of your grievance with relevant dates and witnesses, and your requested resolution or remedy. Is there a time limit for filing a grievance? Yes. You must submit your grievance within 1 year from the date of the incident or circumstance that prompted the complaint. Grievances filed after this period may not be considered valid. How long will it take to get a decision? The Grievance Redressal Committee is mandated to provide a written decision on your grievance within 30 days from the date of receiving your complete application. Complex cases may require additional investigation time, but you will be kept informed of any delays. What if I'm not satisfied with the decision or don't receive a response? If you are dissatisfied with the committee's decision or do not receive any response within the 30-day time frame, you have the right to escalate the matter by filing an application to the conciliation officer within 60 days from the expected response date. Can I appoint a representative during the grievance process? Yes, you have the right to authorize a co-worker, union representative, or other appropriate person to represent your interests when your grievance is being reviewed by the committee. Your representative can speak on your behalf and help present your case effectively. Can I face retaliation for filing a grievance? No, employers are strictly prohibited from taking any adverse or retaliatory action against employees who file grievances. This protection is enshrined in labor laws to ensure employees can exercise their rights without fear of negative consequences to their employment status or work environment. What types of issues can be addressed through the grievance process? The grievance process can address a wide range of workplace concerns including, but not limited to, unfavorable working conditions, discriminatory treatment, wage and benefit disputes, unjust disciplinary actions, denied promotions or transfers. harassment, workplace safety issues, and any violations of company policies, employment contracts, or labor legislation. How is confidentiality maintained during the grievance process? All grievances are handled with strict confidentiality protocols. Information is shared only on a need-to-know basis with committee members and parties directly involved in resolving the issue. Documents related to your grievance are securely stored, and all participants in the process are bound by confidentiality obligations. Frequently asked questions. Standing orders adoption. How do I adopt model standing orders? As an employer, notify the certifying officer electronically about your intended adoption date. Include your company details, industry type, worker count, and which version of the model standing orders you plan to adopt. What happens after I notify the certifying officer? The certifying officer has 30 days to review your notification. They may request modifications if they identify important rules that should be included. During review, they assess whether the model standing orders are appropriate for your establishment and if additional provisions are needed for your industry. What should I do if the officer asks for changes? Submit an electronic report within 30 days confirming you've implemented all requested changes. Detail each modification and provide justification for any requested changes you believe don't apply to your establishment. You may request a time extension with proper reasoning if needed. When are my standing orders considered officially adopted? If the certifying officer doesn't respond within 30 days of your notification, your standing orders are automatically considered adopted and valid. Keep a record of your submission date as proof of the deemed approval. Once adopted, display the standing orders in a prominent location accessible to all employees. Do I need to communicate the standing orders to my employees? Yes. Once adopted, communicate the standing orders to all employees through official notices, emails, employee handbooks, and departmental meetings. Ensure employees understand all terms and conditions, especially those related to conduct, discipline, and grievance procedures. How often should standing orders be reviewed and updated? Review your standing orders at least once every 3 years or whenever significant labor law changes occur. Amendments to existing standing orders must follow the same procedure as adopting new ones, including notification to the certifying officer and obtaining approval. What are the consequences of not adopting proper standing orders? Failure to adopt proper standing orders may result in penalties under labor laws. In disputes, the absence of clear standing orders can disadvantage employers during legal proceedings and lead to inconsistent application of rules across the organization. Common questions about worker representation. Here are answers to frequently asked questions about the representation process when there is no trade union. Who calls the workers' meeting? The certifying officer convenes a meeting of all workers in the absence of a trade union. This meeting must be held in a neutral and accessible location to ensure full participation. How many worker representatives are needed? Workers must elect 3 representatives from among themselves. Ideally, these representatives should come from diverse departments to ensure comprehensive workplace representation. What happens after representatives are selected? The certifying officer provides the standing orders to these 3 representatives, who then review the documents and gather feedback from the workforce they represent. What is the timeline for representatives to respond? Representatives have 15 days from receipt of the standing orders to submit any objections or concerns on behalf of the workers. What is the purpose of this representation process? This mechanism ensures workers can meaningfully participate in workplace governance even without formal union representation, providing a democratic avenue for input on standing orders. Are there term limits for worker representatives? No formal restrictions exist on how many times an individual can serve as a representative, though rotation is encouraged to broaden participation and perspective. What qualifications should worker representatives possess? While no formal qualifications are mandated, effective representatives typically have strong communication skills, workplace familiarity, and the trust of their colleagues. How are objections to standing orders processed? The certifying officer reviews all submitted objections and may facilitate a joint discussion between management and worker representatives to address concerns. What occurs if workers fail to select representatives? If representatives are not selected within the designated time frame, the certifying officer may either proceed with certification without worker input or extend the selection period. FAQs on authentication of standing orders. How are standing orders authenticated? The certifying officer or appellate authority authenticates the standing orders or amendments after approval. This authentication verifies that the orders comply with all legal requirements and have undergone proper review. When will we receive the authenticated standing orders? You will receive electronic copies within 1 week of authentication. Hard copies are also available upon request for your official records. Are there any cases where certification is not required? Certification is not required in 2 scenarios: when standing orders are automatically approved after the statutory time limit expires, or when an employer adopts model standing orders without any modifications. What information appears on the authenticated copy? The authenticated copy includes the certifying officer's signature, official stamp, authentication date, and a unique certification number for future reference. How long are authenticated standing orders valid? Authenticated standing orders remain valid indefinitely until formally modified through the proper amendment procedure, or completely replaced with new orders. What should we do if we notice errors in the authenticated standing orders? If you identify any discrepancies, contact the certifying officer immediately. Minor clerical errors can typically be corrected without repeating the entire certification process. Who must display the authenticated standing orders? Employers are legally responsible for displaying the authenticated standing orders in prominent locations accessible to all workers, often in multiple languages where the workforce requires it. All relevant stakeholders, including employer representatives, worker representatives, and appropriate government authorities, will receive copies of the authenticated standing orders. For compliance purposes, records documenting receipt should be maintained by all parties. Common questions about draft standing orders. What information must be included when submitting new standing orders? You must provide essential details including company name, address, email, phone number, worker count, and trade union information. This ensures proper processing of your application and facilitates communication if additional information is required. What should I include when amending existing standing orders? Submit a comparative table showing current provisions, proposed amendments, and justifications for each change. Your rationale should clearly demonstrate why each modification is necessary to facilitate efficient review. Who needs to sign a submission? An authorized representative of your company must sign the statement to validate the submission. This typically includes directors, managing partners, or designated officers with proper authorization authority. Is there a required format for draft standing orders? Yes. Submit draft standing orders in triplicate with clear section headings and sequential numbering. Each provision should be concise and written in plain language that is easily comprehensible to all employees. What is the standard approval timeline? The certifying officer must make a determination within 45 days of submission. This period may be extended if additional clarifications or modifications are requested during the review process. What happens if no response is received within the specified time frame? If no response is received within the statutory period, typically 45 days, your standing orders are deemed certified and approved as submitted, unless you've been formally notified of a time extension. Adhering to these requirements ensures comprehensive documentation when submitting or modifying standing orders. Careful compliance with these guidelines will expedite the certification process and minimize the risk of delays or rejections. FAQs, Joint Draft Standing Orders. Essential information about how groups of employers in the same industry can collaborate to establish uniform workplace regulations. What are joint draft standing orders? These are collaborative workplace regulations created by similar businesses after thorough consultation with workers' unions. They establish consistent employment standards across multiple establishments with similar operations, ensuring uniformity in working conditions and employee treatment. Where should we submit joint standing orders? Submit all documentation to the Chief Labor Commissioner Central. Your submission must include comprehensive documentation and authorized signatures from all participating establishments to be considered valid. Who has authority to approve these joint regulations? The Chief Labor Commissioner collaborates with designated certifying officers to evaluate and either approve or reject the proposed standing orders. This involves a meticulous review process to verify compliance with current labor laws and industry-specific regulations. Will we receive detailed feedback on approval or rejection? Yes, the authorities must provide clear written justification for their decision. This transparency ensures businesses understand exactly which elements require modification if rejected, or which aspects were deemed appropriate if approved. Can businesses from different industries submit joint standing orders? No, only businesses conducting similar operations within the same industry can submit joint standing orders. For instance, multiple automotive manufacturers could collaborate, but an automotive company and a food processing business could not jointly submit. Is there a maximum number of businesses that can participate? There is no specified limit on participating businesses. provided all establishments operate within the same industry sector and demonstrate sufficiently similar working environments to justify unified standing orders. How are modifications handled after joint standing orders are certified? Individual businesses cannot independently modify certified joint standing orders. Any proposed changes must be collectively submitted by all participating establishments and undergo the same rigorous approval process as the original documentation. What benefits do joint standing orders offer? Joint standing orders provide significant advantages including administrative efficiency, industry-wide standardization, reduced compliance costs for individual businesses, simplified union negotiations, and consistent implementation of labor practices across similar establishments. FAQs, Appeal Against Standing Orders, essential information about the appeal process for certified standing orders and what stakeholders should expect during proceedings. Who can file an appeal against standing orders? Both employers and trade unions have the right to file appeals if they disagree with the certifying officer's decision. Workers may file appeals through their registered trade union representatives. Multiple parties sharing common concerns may submit joint appeals to streamline the process. What is the time limit for filing an appeal? Appeals must be submitted within 60 days of receiving the certifying officer's order. The appellate authority may, at its discretion, consider late appeals if compelling reasons for the delay can be substantiated. How should the appeal be formatted? Appeals must be presented in table format, clearly identifying the contested sections, proposed modifications, and comprehensive justification for each requested change. This structured approach ensures all aspects of your appeal are systematically addressed. What happens after filing an appeal? The appellate authority will schedule a hearing within approximately 30 days and notify all parties involved. You will receive formal written communication detailing the hearing date, time, location, and procedural requirements to follow. Do I need to share my appeal with others? Yes, appellants must provide a copy of the appeal to each respondent to maintain transparency and allow all affected parties adequate preparation time. The appellate authority may require proof that this notification requirement has been fulfilled. How does the appeal authority reach decisions? The authority conducts a thorough review process, examining written submissions, evaluating oral arguments, and potentially requesting supplementary documentation. Decisions are based on applicable legal provisions, established industry practices, and principles of natural justice after all parties have been heard. Can I withdraw my appeal once filed? Yes, appellants may withdraw their appeal by submitting a formal written request to the appellate authority prior to the final ruling. All involved parties must be promptly notified of the withdrawal decision. What recourse exists if dissatisfied with the appeal decision? Parties dissatisfied with the appellate authority's ruling may pursue further legal remedies through the judicial system, typically by filing a writ petition with the appropriate high court within the legally prescribed time frame. FAQs, Maintaining Standing Orders. What languages must standing orders be kept in? Standing orders must be maintained in Hindi or English and in the official language of the state where your workplace is located. This ensures all workers can access them and complies with both national and state regulations. How are certified standing orders distributed? Certified standing orders are transmitted electronically, except in cases of deemed certification, automatic certification. This electronic delivery ensures prompt receipt and creates a verifiable digital record of the certification process. Who is responsible for maintaining standing orders? The employer bears responsibility for maintaining standing orders in all required languages after certification. This includes ensuring they remain accessible to all employees, keeping them current, and enforcing compliance throughout the workplace. What happens after standing orders receive certification? Post-certification, employers must maintain the orders in all mandated languages and distribute them electronically in most circumstances. Additionally, employers must display these standing orders prominently at the workplace where all employees can easily access and review them. How frequently should standing orders be reviewed? While no mandatory review period exists, best practice suggests reviewing standing orders annually or whenever significant workplace changes or labor law amendments occur. This ensures they remain relevant and legally compliant. Can standing orders be modified after certification? Yes, certified standing orders can be modified, but the modification process must follow the same procedure as the original certification. Employers must submit all proposed amendments to the certifying officer for formal approval. What penalties apply for improper maintenance of standing orders? Employers failing to maintain certified standing orders in required languages or properly display them may face legal penalties, including monetary fines. Repeated non-compliance may result in more severe legal consequences under applicable labor laws. Do employees require notification about standing orders? Yes, employers must ensure all employees are informed about and understand the standing orders. This typically involves providing documentation during new employee orientation and conducting regular awareness sessions for existing staff. How should electronic copies of standing orders be secured? Electronic copies require secure storage with robust backup systems. Access controls should ensure the documents remain available to authorized personnel while preventing unauthorized modifications or deletions. Common questions about standing order registers. How are standing order records maintained? Certifying officers maintain all standing order records in a secure electronic register. This comprehensive database includes certified orders, deemed certified orders, and adopted model standing orders. All records undergo regular backups to ensure data integrity and prevent loss. What information does the register contain? The register includes a unique identification number for each order, the establishment name and category, certification date, operational jurisdiction, and other essential details. It also documents the chronology of modifications made to standing orders over time. How can I obtain a copy of a standing order? Any individual can request a copy by paying a fee of 2 rupees per page. Payments can be processed electronically through the authorized payment portal. Who is responsible for register management? The certifying officer holds primary responsibility for register maintenance. They ensure accurate data entry, proper organization, and timely updates whenever changes occur to any standing orders. What is the retention period for standing orders in the register? Standing orders remain in the register throughout their effective period, plus an additional archival period after they are superseded or become obsolete, ensuring historical records are preserved. Is the register accessible online? Yes, the register is accessible through a secure online portal for authorized personnel. Public access is restricted to specific information and requires proper authentication and authorization. What is the procedure for correcting register errors? If you identify errors in the register, promptly notify the certifying officer. After verification of the correct information, they have the authority to implement necessary corrections to maintain register accuracy. Modification of standing orders (FAQs). Essential information about modifying existing standing orders in your workplace. What is a standing order modification? A formal procedure to amend existing workplace rules and regulations. Requires clear documentation of proposed changes and justification. Enables adaptation of workplace policies to evolving circumstances. Ensures a transparent and equitable process for all stakeholders. What information must I include in my application? Current standing orders alongside proposed amendments. Comprehensive justification for each modification. Details of all registered trade unions at the workplace. Implementation date of the current standing orders. History of previous modifications, if any. Records of consultation meetings with worker representatives regarding the proposed changes. How should I format my application? Present a comparative table showing current rules and proposed amendments in separate columns. Include a distinct column for justifications. Use sequential numbering for each modification. Implement clear section headings for easy navigation. Attach a concise cover letter summarizing key modifications. Provide a comprehensive index of all requested changes. What is the submission process? Submit all applications electronically through the certifying officer. Physical applications are not accepted. Use the official workplace regulations portal with your registered employer credentials. You will receive a confirmation receipt and reference number upon successful submission. Is trade union notification mandatory? Yes, all registered trade unions at your workplace must be included in your application. Provide documentation confirming you have shared the proposed modifications with union representatives at least 21 days before submission. Trade unions retain the right to submit their feedback directly to the certifying officer. What is the review process after submission? The certifying officer conducts a thorough review within 30 working days. Additional information or clarification may be requested if necessary. If trade unions raise objections, a formal hearing may be scheduled. Both parties will have the opportunity to present their perspectives before a final determination. Can modification requests be denied? Yes, the certifying officer may reject modifications that contravene labor laws, industry standards, or established workplace rights. Rejected applications will include a detailed explanation of concerns. You may resubmit after addressing the identified issues. You have the right to appeal decisions within 15 days of notification. What is the typical timeline for the modification process? The complete process generally requires 45 to 60 days from submission to final approval. Complex modifications or those with significant objections may require additional time. Plan accordingly and refrain from implementing changes until receiving official authorization. FAQs, Notice of Change in Service Conditions. What notice must employers give when changing service conditions? Employers must provide a notice using Form 2 when modifying service conditions listed in the third schedule. The notice must clearly outline all proposed changes and specify their implementation date. All information must be presented in clear, accessible language that every worker can easily understand. Where should the notice be displayed? The notice must be prominently posted on the notice board at the main entrance of the workplace. A copy must also be displayed in the manager's office. The notice must remain visible until the changes take effect. Employers are responsible for ensuring all workers can easily see and access the notice. Do employers need to inform trade unions about these changes? Yes. Employers must provide a copy of the notice to the secretary of any registered trade union in the workplace. If multiple trade unions exist, each union secretary must receive their own copy. Employers should maintain documentation proving delivery of these notices to trade unions. How much advance notice must be given before implementing changes? A minimum 21-day notice period is required before any service condition changes can be implemented. This period ensures workers and their representatives have sufficient time to review and respond to the proposed changes. Can workers object to the proposed changes? Yes. Workers or their trade union representatives have the right to submit objections to the proposed changes. All objections must be submitted in writing within 14 days of the notice being posted. Employers must review and respond appropriately to all objections received. What happens if employers fail to provide proper notice? Changes implemented without proper notice may be deemed legally invalid and unenforceable. Employers may face legal consequences, including penalties and potential litigation, for failing to comply with statutory requirements for modifying service conditions. Common questions about arbitration. What is a voluntary arbitration agreement? When employers and workers agree to resolve their dispute through an independent arbitrator, they must formalize this arrangement by signing a Form 3 agreement. The arbitrator must also provide written consent. This process offers an efficient alternative to litigation, saving both time and financial resources for all parties involved. Who can sign the arbitration agreement? Employers, either the employer directly or any authorized representative with proper delegated authority. Workers as a collective, an official trade union representative or 3 worker representatives democratically elected by majority vote. Individual workers, the worker personally or a trade union officer, acting as their authorized representative. Does the government need to be notified about the arbitration? Yes. When the government confirms that a sufficient majority from each party has consented to arbitration, they will issue an official notification in the Gazette and on relevant online platforms. This public announcement ensures procedural transparency throughout the arbitration process. Are specific forms required for arbitration? Yes. Form 3 must be used for documenting the arbitration agreement. This standardized form ensures the process is officially recognized and that all essential information is properly recorded in compliance with labor regulations. What is the typical duration of the arbitration process? The time frame varies based on dispute complexity, but most arbitration proceedings conclude within 30 to 60 days after the arbitrator's appointment. This represents a significant efficiency improvement compared to traditional court proceedings. Can parties contest an arbitration decision? While arbitration decisions are generally considered final and binding, they may be challenged under specific limited circumstances, including fraud, arbitrator misconduct, or instances where the arbitrator exceeded their jurisdictional authority. Any challenge must be filed within 90 days of receiving the decision. What expenses are associated with the arbitration process? Typical costs include arbitrator fees, administrative expenses, and potentially legal representation. These expenses are normally divided equally between employers and workers, unless alternative arrangements are specified in the arbitration agreement or determined by the arbitrator's ruling. Worker representation in arbitration. Frequently asked questions. Key questions regarding worker representation during arbitration proceedings when no trade union exists. Who represents workers without a trade union? Workers elect their representatives through a democratic majority voting process. These elected individuals advocate for the collective workforce during arbitration proceedings. How are these representatives elected? Representatives are selected during a formal meeting with majority worker attendance. The election requires a transparent voting process where the majority agree on their chosen representatives. Typically, at least 3 workers are selected to ensure comprehensive representation. Is there required documentation? Yes, the selection must be officially recorded in Form IV. This documentation must be completed accurately and submitted to the appropriate authorities, serving as legal verification of the workers' chosen representation. Are all workers bound by representatives' decisions? Yes, all workers are legally bound by the actions and decisions of their elected representatives. This binding nature underscores the importance of thoughtful selection, as these representatives will make commitments on behalf of the entire workforce. What occurs during the selection meeting? Workers convene at a designated location to discuss potential candidates, hear from willing nominees, and conduct a formal majority vote. All meeting proceedings should be properly documented for transparency and legal purposes. Can representatives be replaced? Yes, if the majority of workers determine their representatives are not effectively advocating for their interests, they may convene another meeting following the same formal process to select new representatives and complete updated documentation. What qualifications should representatives possess? While no formal qualifications are legally mandated, effective representatives typically demonstrate strong communication skills, comprehensive understanding of labor issues, and maintain the trust of their colleagues. The ability to clearly articulate workers' concerns during arbitration is essential. May representatives seek external assistance? Representatives may consult with legal advisors or labor experts, though these external parties cannot directly represent workers in arbitration unless specifically authorized by the arbitration agreement or applicable labor regulations.
Common questions. National Industrial Tribunal judicial members. Who appoints judicial members? The central government appoints members based on recommendations from a specialized selection committee. This committee comprises the Chief Justice of India, or their nominee, as chairperson, a serving judicial member from another national industrial tribunal, the Secretary of the Ministry of Labour, the Secretary from the Department for Promotion of Industry. The rigorous appointment process ensures candidates possess both judicial expertise and industrial knowledge essential for effective dispute resolution. What qualifications do judicial members need? Candidates must satisfy the eligibility criteria specified in Section 46(3) of the Code. These criteria establish the professional standards for this significant judicial position. Specifically, eligible candidates must be or have been a High Court judge, possess at least 5 years of experience as a district judge or additional district judge, demonstrate comprehensive knowledge of labor and industrial legislation, exhibit unquestionable impartiality and judicial temperament. How long can someone serve as a judicial member? Judicial members serve for a term of 4 years from their appointment date. However, their tenure concludes upon reaching 65 years of age, even if this occurs before completing the full 4-year term. This fixed-term policy balances the need for fresh judicial perspectives with institutional continuity. What are the key responsibilities of judicial members? Judicial members fulfill several critical functions: adjudicating industrial disputes between employers and workers, authoritatively interpreting labor laws and industrial regulations, conducting fair and impartial hearings for all parties, delivering binding judgments on complex labor disputes, contributing to the development of consistent labor jurisprudence. Can judicial members be reappointed? Yes. Judicial members are eligible for reappointment following their initial 4-year term, provided they have not reached the age limit of 65 years. The reappointment procedure mirrors the initial appointment process, requiring recommendation from the selection committee and subsequent approval by the central government. Frequently asked questions. Judicial member compensation. Comprehensive answers to common questions about National Industrial Tribunal judicial member compensation. What is the monthly salary of a judicial member? 225,000 rupees fixed per month, plus allowances equivalent to those received by Group of Government of India officers. This compensation package reflects the high-level expertise and significant responsibilities demanded by this senior judicial role. How does pension affect the salary for retired High Court judges? For retired High Court judges, the gross pension amount is deducted from the standard salary. This adjustment ensures fair compensation across all judicial members while accounting for existing retirement benefits. What housing benefits are provided? Members may choose between rent-free furnished accommodation maintained to appropriate standards or a house rent allowance comparable to that received by a group of government officers in the same locality. What leave benefits are available? Leave benefits vary by status. Serving High Court judges maintain the same leave benefits they currently receive, including casual leave, earned leave, and other special provisions. Retired High Court judges receive leave benefits equivalent to group of government officers, including earned leave, health pay leave, casual leave, and other standard provisions. What healthcare coverage is provided? Members receive comprehensive central government health scheme, CGHS benefits, including access to impaneled hospitals, outpatient care, specialized treatments, and medical reimbursements. Family members also receive coverage according to standard CGHS guidelines. Are there any retirement benefits for judicial members? Members appointed for fixed terms receive gratuity based on their length of service as a judicial member. They may also qualify for Provident Fund contributions during their tenure. What transportation allowances do judicial members receive? Members receive either an official vehicle for their duties or a transport allowance equivalent to that of similarly ranked group of government officers. Fuel allowances and maintenance costs are covered per government guidelines. Frequently asked questions. Judicial member benefits. Essential information about benefits and provisions for National Industrial Tribunal judicial members. What travel benefits do judicial members receive? Travel allowances equivalent to Group of Government of India officers. Retired High Court judges receive one-time joining and relocation allowances for expenses when moving to their place of posting. All members are entitled to comprehensive leave travel concessions for themselves and their families, including appropriate Class Air travel. Monthly transport allowances are provided for official vehicle maintenance or private transportation arrangements. Who approves leave for judicial members? The central government, through the designated ministry or department, serves as the approving authority for all leave requests. Members must submit applications in the prescribed format with appropriate supporting documentation. In emergencies, provisional approval may be granted, subject to subsequent formal approval. Can judicial members travel abroad for official work? Yes, members may travel abroad for official purposes such as international conferences, symposiums, training programs, or bilateral meetings with prior central government approval. The approval process requires a detailed proposal outlining the purpose, duration, and expected outcomes. Members must submit a comprehensive report about the visit and its benefits upon return. Are health checks required before joining? Yes. All appointed judicial members must undergo a comprehensive medical examination and obtain a fitness certificate from an authorized government medical officer or recognized hospital before assuming office. This ensures members are physically and mentally fit to discharge their duties effectively. The examination typically covers cardiovascular health, vision, hearing, and other essential health parameters relevant to judicial work. What must members do before starting work? Judicial members must take a formal oath of office and secrecy as prescribed in Form V of the relevant rules. This ceremony is conducted in the presence of a designated authority such as the tribunal chairperson or senior government official. The oath commits members to uphold the Constitution, maintain confidentiality, and discharge duties impartially. Members must also complete administrative formalities including asset declaration, credential verification, and submission of joining reports. Judicial member misconduct. Common questions. What happens when someone complains about a judicial member? When the central government receives a written complaint regarding a judicial member's misconduct, it conducts an initial verification of the complaint's validity. This preliminary assessment evaluates the complaint's seriousness, credibility, and relevance to the member's official conduct. Anonymous complaints are generally not considered for further action. Who investigates these complaints? If the complaint is deemed credible, the central government directs the Search-cum-Selection Committee to conduct a thorough investigation. The committee establishes a specialized inquiry panel comprising senior officials with relevant expertise to comprehensively examine the allegations. What is the timeline for completing an investigation? The committee typically concludes its investigation within 6 months. In cases involving complex issues or requiring extensive evidence collection, the central government may grant an extension. During this investigation period, the member may be temporarily relieved of certain official responsibilities. What follows the completion of an investigation? The committee submits a comprehensive report to the central government detailing their findings and providing reasoned conclusions for each allegation. The report includes specific recommendations regarding whether disciplinary action is warranted and the appropriate measures to be implemented. Is a judicial member permitted to continue their duties during an investigation? Generally, judicial members may continue performing their official functions during an investigation unless the allegations are exceptionally serious. However, in cases involving grave misconduct, the central government may suspend the member or limit their jurisdictional responsibilities pending the inquiry's conclusion. What range of disciplinary actions can be imposed? Disciplinary measures range from formal reprimands and temporary suspension to permanent removal from office. The severity of the action corresponds to the nature of the misconduct, its impact on the integrity of the judicial system, and whether there exists a pattern of improper conduct. Do judicial members have the right to appeal against disciplinary actions? Yes. Judicial members are entitled to appeal any disciplinary action taken against them. They must submit a formal written appeal to the designated appellate authority within 30 days of receiving notification of the action. The appellate process ensures the member has an opportunity to present their case and submit evidence in their defense. Frequently asked questions. Judicial member leaving the position. How can a judicial member resign? A judicial member must submit a formal written resignation to the central government. Following submission, they are typically required to serve a 3-month notice period, unless granted earlier release. The resignation letter should explicitly state their intention to vacate the position and specify their proposed final day of service. When does a resigning member complete their service? A resigning member's service concludes upon the earliest occurrence of completion of the 3-month notice period, appointment of their successor, or expiration of their original term. Throughout this transition period, the member is responsible for resolving pending cases and fulfilling remaining obligations to facilitate a seamless handover. What are the grounds for removal of a judicial member? A judicial member may be removed if they are declared insolvent, are convicted of a criminal offense involving moral turpitude, become physically or mentally incapacitated, acquire financial or other interests that may compromise their impartiality, or abuse their official position in a manner detrimental to public interest. Removal proceedings commence only after substantial evidence supporting such circumstances has been presented. Who has the authority to remove a judicial member? While the central government holds the ultimate authority to remove a member, such action can only be taken upon receiving a formal recommendation from the Search-cum-Selection Committee. This procedural safeguard ensures that removal decisions are justified and follow thorough investigative protocols. The member is afforded an opportunity to present their defense before the final determination. Is there a mandatory retirement age for judicial members? Yes. Judicial members must mandatorily retire upon attaining 65 years of age, irrespective of their tenure duration. Members approaching this age threshold receive advance notification several months prior to facilitate proper transition planning. Can a removed judicial member contest the decision? Yes. A judicial member removed from office has the right to challenge the decision through appropriate legal channels. They must file their appeal within the stipulated time frame, generally 90 days from the removal order date, and provide substantiating evidence to support their contestation. What post-service benefits are available to judicial members? Upon completion of service, judicial members may be eligible for pension benefits, gratuity payments, and other retirement entitlements in accordance with government regulations. The specific benefits package depends on their length of service, circumstances of departure, and the conditions outlined in their original appointment letter. National Industrial Tribunal, Administrative Member FAQs. What qualifications are needed? Candidates must meet the requirements in subsection 4 of section 46 of the code. This includes substantial experience in labor law, industrial relations, or relevant administrative positions. Applicants should demonstrate expertise in industrial dispute resolution and comprehensive knowledge of applicable legislation. Who selects administrative members? The central government appoints members based on recommendations from a search committee. This committee comprises the Chief Justice of India, or nominee, as chairperson, a serving administrative member from another national industrial tribunal, the Labour Ministry Secretary, and the Secretary from the Department for Promotion of Industry and Internal Trade. Selection involves rigorous assessment of qualifications, experience, and aptitude. How long can someone serve as an administrative member? Members serve for a term of 4 years or until reaching 65 years of age, whichever occurs first. The position has no provision for term extensions beyond these established limits. What is the salary and benefits package? Members receive a fixed monthly salary of 225,000 rupees plus allowances comparable to Group of Government of India officers. For retired government servants, pension amounts are deducted from this compensation. The comprehensive benefits package includes housing, travel, and healthcare provisions. What are the main responsibilities of an administrative member? Administrative members contribute to industrial dispute resolution by participating in tribunal proceedings, evaluating evidence, applying relevant laws, and helping formulate fair judgments. They collaborate with judicial members to ensure balanced decisions that integrate both legal principles and administrative expertise. Is prior experience with tribunals required? While tribunal experience is advantageous, it's not always mandatory. Candidates with extensive background in labor administration, industrial relations, or equivalent fields are considered when they demonstrate sufficient expertise in industrial dispute resolution mechanisms. What is the application process? The central government announces vacancies through official notifications periodically. Applicants must submit comprehensive applications detailing their qualifications, experience, and supporting documentation. Shortlisted candidates then undergo interviews with the search-cum-selection committee before final appointments are made. Are there any restrictions on other employment? During their tenure, administrative members cannot hold any other office of profit or engage in business, professional, or occupational activities that might conflict with their tribunal duties. Members must disclose all financial interests to maintain transparency and prevent conflicts of interest. Common questions about administrative member benefits. What housing benefits do administrative members receive? Members are entitled to furnished accommodation or housing allowance. If government housing is unavailable, members receive house rent allowance, HRA, at rates applicable to Group A officers in that location. Standard accommodation is typically Type 6 or equivalent, ensuring appropriate living conditions throughout their tenure. What travel allowances are provided? Members receive travel allowances equivalent to highest grade Group A officers, including an annual home travel concession for themselves and their immediate family. Daily transport allowance covers local commuting needs, while official travel expenses including accommodation and meals are fully reimbursed per government guidelines. Are there special relocation benefits for retiring government officers? Yes. Retiring officers receive comprehensive relocation assistance, including reimbursement for packing and transporting household goods, temporary accommodation allowances during transition, and a one-time settlement grant to facilitate smooth relocation to their new posting. What leave entitlements do administrative members have? Serving government officers retain their existing leave benefits according to their service rules. Retired officers receive leave benefits equivalent to Group A officers 430 days of annual earned leave, 8 days of casual leave, and applicable medical leave. Leave may be accumulated within specified limits as per service regulations. What is the leave approval process? All leave requests require central government approval, typically from the Ministry of Labour and Employment. Applications should be submitted at least 2 weeks in advance for planned absences, except in emergencies. Members must ensure their absence will not disrupt tribunal proceedings. What healthcare benefits are provided? Members have access to Central Government Health Scheme, CGHS, services at all impaneled facilities. Coverage includes outpatient consultations, diagnostic tests, emergency services, and hospitalization for members and eligible family dependents. Alternative healthcare arrangements may be approved for members residing outside CGHS-covered cities. Are there medical fitness requirements? Yes. Candidates must submit a medical fitness certificate from a government-authorized practitioner before appointment. The certificate must specifically confirm the candidate's fitness to discharge administrative member duties. Periodic health assessments may be recommended throughout the tenure to ensure continued fitness for service. Administrative member, misconduct and removal. FAQs. How are misconduct complaints handled? The central government conducts a preliminary examination of all written complaints to verify their authenticity and merit. This initial screening effectively filters out frivolous or unsubstantiated allegations and safeguards members from harassment through baseless complaints. What happens if a complaint seems valid? If sufficient grounds for investigation exist, the matter is referred to a specially constituted inquiry committee. This committee, typically comprising senior officials and legal experts, must complete its investigation within 6 months. They meticulously examine evidence, interview relevant witnesses, and prepare a comprehensive report with detailed recommendations. How can a member resign from their position? A member may tender their resignation by submitting a written notice to the central government. Following submission, they must continue in office for 3 months, until a successor assumes the position, or until their term expires for whichever occurs first. This transition period ensures operational continuity and smooth functioning of the tribunal. When can a member be removed from their position? Grounds for removal include insolvency, conviction for a criminal offense involving moral turpitude, physical or mental incapacity affecting performance, demonstrated bias in official proceedings, or abuse of position. The removal process requires formal documentation and authorization from the appropriate governmental authorities. What is the procedure after the inquiry committee submits its report? Upon submission of the inquiry committee's report, the central government thoroughly reviews the findings and recommendations. If misconduct is substantiated, the government may issue a show cause notice to the member, requiring an explanation, before determining appropriate disciplinary action or proceeding with removal. Can a member contest their removal? Yes. Members are entitled to present a comprehensive defense against removal proceedings. They may submit written representations, request personal hearings, and in certain circumstances, challenge the decision through established legal channels if they believe the removal was unwarranted or procedurally flawed. Are there any interim measures during misconduct investigations? Based on the nature and severity of allegations, the central government may implement temporary suspension of a member during the investigation period. While suspended, the member typically receives a subsistence allowance but is prohibited from exercising official powers until exonerated of all charges. Conciliation proceedings. FAQs. What happens when a dispute application is received? The conciliation officer meticulously reviews the application and supporting documents. If the dispute falls outside their jurisdiction or geographical area, they transfer it to the appropriate state government authority within 7 days of receipt. How do conciliation proceedings begin? The conciliation officer issues a formal notice to all parties involved, both employers and workers, detailing the commencement of proceedings. This notice specifies the date, time, and venue for the first meeting, which must be scheduled within 7 days of application receipt. What happens in the first meeting? All parties present their perspectives through detailed written statements. The conciliation officer establishes a conducive environment for open dialogue, ensuring each party has equal opportunity to express their concerns and expectations. How does the conciliation officer facilitate dispute resolution? The officer conducts multiple joint and separate meetings with the involved parties. They employ specialized mediation techniques, propose potential compromises, clarify misunderstandings, and work impartially to help both sides reach a fair, mutually acceptable, and sustainable agreement. What is the time frame for completing conciliation proceedings? The conciliation officer must conclude the proceedings within 30 days from the date of the first meeting. For complex disputes, this period may be extended by an additional 30 days with appropriate justification. What occurs when a settlement is successfully reached? Upon reaching an agreement, the conciliation officer drafts a settlement document that all parties must sign. This settlement carries the same legal weight as an arbitration award and becomes legally binding on all involved parties. Are conciliation proceedings confidential? Yes. All information disclosed during conciliation proceedings is strictly confidential. Both the conciliation officer and all participating parties must maintain complete confidentiality about the proceedings, and this information cannot be used as evidence in any subsequent legal proceedings. Frequently asked questions. Key information about post-conciliation procedures. What happens if no settlement is reached during conciliation? The conciliation officer files a detailed report on the Samadhan portal within 7 days of concluding the proceedings. This report documents all reconciliation attempts and explains why the dispute remained unresolved. Who can access the conciliation report? All concerned parties have full access to the report through the Samadhan portal. The document comprehensively details each party's position, the conciliation officer's mediation efforts, factors that prevented settlement, and the final outcome, ensuring complete transparency. How do I refer my unresolved dispute to the tribunal? Any party can refer the dispute to the tribunal by submitting Form 6 through the Samadhan portal within 90 days of the conciliation report's issuance. Applications filed after this period may face dismissal unless substantial justification for the delay is provided. What are my responsibilities after applying to the tribunal? If you initiated the dispute, you must file a comprehensive statement of claim with all relevant details and supporting documentation within 30 days. Your statement should clearly articulate the specific relief sought and the legal basis for your claim. What are the consequences of missing the statement of claim deadline? Failure to submit your statement within the stipulated 30-day period may result in application dismissal. However, in exceptional circumstances, you may request an extension by filing a formal application with detailed justification for the delay. Is it possible to amend my claim after submission? You may petition the tribunal for permission to modify your statement of claim. Such requests should be submitted at the earliest stage of proceedings. The tribunal exercises discretionary power to permit or deny amendments based on the merits of your justification. What procedures follow if the opposing party fails to respond? If the responding party neither appears nor files a reply, the tribunal may conduct an ex parte hearing. Proceeding in the absence of one party, the judgment will be based solely on evidence presented by the participating party. Is legal representation mandatory at tribunal proceedings? Legal representation is optional, not mandatory. You may represent yourself or authorize representation by a trade union official, colleague, or legal practitioner. Any authorization must be formally documented and submitted to the tribunal prior to proceedings. Tribunal hearing process. Frequently asked questions. When is the first hearing scheduled? The tribunal schedules a first hearing within 1 month after receiving your application. Once all parties have the necessary documents, you'll receive notification of the date, time, and venue through the Samadhan portal and your registered contact details. For rescheduling due to unavoidable circumstances, submit a request at least 7 days before the scheduled date. When must I submit my written statement? Submit your written statement with supporting documents within 30 days of the first hearing, and send copies to all involved parties. Your statement should clearly outline your position, relevant facts, and legal grounds. If you need an extension, file a formal request with justification before the deadline. How is evidence recorded during the process? Evidence can be recorded directly at the tribunal or through signed affidavits. You have the right to question the opposing party's evidence. The tribunal maintains written notes of all oral testimony following standard legal procedures. All documentary evidence must be properly indexed and authenticated, while digital evidence must follow the format guidelines on the Samadhan portal. When do arguments take place? Arguments occur either immediately after evidence presentation or within 15 days afterward. Each party typically receives 30 to 45 minutes for presentation, with additional time possible for complex cases at the tribunal's discretion. The tribunal may also request written submissions to supplement oral arguments. Can I represent myself or do I need a lawyer? Self-representation is permitted before the tribunal. However, due to legal complexities, professional representation is recommended, especially for complicated disputes. If representing yourself, tribunal staff can provide procedural guidance but cannot offer case-specific legal advice. What happens if new evidence emerges during the proceedings? For newly discovered evidence after documentation submission, file an application requesting permission to introduce it. The tribunal will evaluate its admissibility based on relevance and why it wasn't included earlier. The opposing party will have an opportunity to respond to any newly admitted evidence. How long does the entire tribunal process usually take? The tribunal strives to resolve disputes within 6 months from application. Actual duration varies based on case complexity, party cooperation, and the tribunal's caseload. Consistent attendance and prompt document submission can expedite the process. For additional questions about the tribunal hearing process, contact tribunal staff for assistance. Further resources and guidance are available in the resources section of the Samadhan portal. Frequently asked questions about tribunal procedures. How many times can a hearing be postponed? The tribunal typically permits a maximum of 3 postponements, each generally limited to 1 week. All requests must be submitted in writing with valid justification at least 48 hours before the scheduled hearing. The tribunal may decline requests that appear intended to cause unnecessary delays in proceedings. What happens if I miss my hearing? If you fail to attend, the tribunal may proceed without you and make decisions based on available evidence, ex parte. However, this decision can be reversed if you file an application within 30 days explaining your absence with a valid reason. Acceptable justifications typically include medical emergencies, unavoidable travel disruptions, or documented family emergencies. How will I receive the tribunal's decision? The tribunal distributes decisions electronically to all parties and the central government, and uploads them to the Samadhan portal within 1 month of announcement. You can access the decision by logging into your registered account. Physical copies are available upon request for an additional administrative fee if needed for official purposes. Are tribunal hearings open to the public? Yes. Hearings are generally public. However, video conferencing options may be available, and private hearings can be arranged by tribunal order. Requests for private hearings require demonstration of special circumstances such as protection of trade secrets, national security concerns, or protection of vulnerable witnesses. Submit such requests at least 14 days before the scheduled hearing. Can I represent myself or do I need a lawyer? You may represent yourself at tribunal hearings, appearing in person. However, considering the complexity of labor laws and tribunal procedures, engaging a lawyer or authorized representative with industrial dispute experience is often beneficial. Some jurisdictions offer free legal assistance programs for eligible individuals. Check with the tribunal's administrative office for availability. What documents should I bring to the hearing? Bring all documents referenced in your written submissions including employment contracts, correspondence, witness statements, and supporting evidence such as photographs or videos. Organize these chronologically with an index and bring 3 copies, 1 for yourself, 1 for the tribunal, and 1 for the opposing party. Ensure electronic evidence is properly authenticated and accessible during proceedings. How long do tribunal proceedings typically last? Duration varies based on case complexity, evidence volume, and witness count. Simple cases may resolve in 1-2 hearings, while complex disputes might require multiple sessions over several months. The Industrial Relations Code aims to resolve disputes within 90 days where possible, though extensions may be granted for complicated cases requiring additional investigation or evidence. FAQs. About strike notices. Essential information regarding the proper filing and handling of strike notices under labor regulations. What form do I need to submit for a strike notice? Form 7 is the required documents for filing a strike notice. The form must be completed in full, including comprehensive details about the planned strike and a thorough explanation of the grievances or reasons necessitating the industrial action. Who needs to sign the strike notice? The strike notice requires signatures from both the trade union secretary and 5 elected representatives of your registered union. All signatures must be original and dated to ensure validity of the document. Who should receive copies of the strike notice? Copies must be officially submitted to the conciliation officer with jurisdiction in your area, the Chief Labor Commissioner Central, and the central government. Electronic submission is acceptable, but maintain records of all communications and receipt confirmations. When should I submit the strike notice? According to Section 62(1) of the Industrial Relations Code, the notice must be submitted prior to initiating any strike action. This mandatory pre-notification period is designed to provide an opportunity for dispute resolution through dialogue and negotiation. How much advance notice is required? A minimum of 14 days notice must be provided before the intended commencement of the strike. This statutory cooling-off period serves to allow sufficient time for conciliation efforts, mediation proceedings, and potential resolution of the underlying issues. Where should the strike notice be displayed? The notice must be prominently displayed on the establishment's physical notice board and electronic information displays, particularly at the main entrance. This ensures transparency and proper information dissemination to all workers and management personnel affected by the potential action. Can a strike notice be withdrawn? Yes, if negotiations yield favorable outcomes. The trade union secretary has the authority to withdraw the strike notice by submitting a formal withdrawal letter to all the same authorities who received the original notice. The withdrawal should clearly indicate the resolution reached. What happens if strike procedures are not followed correctly? Non-compliance with proper strike notice procedures may result in the strike being declared illegal under labor laws. This could lead to serious consequences, including disciplinary action against participating workers, potential legal liability for union representatives, and invalidation of any protections typically afforded to striking workers. Lockout notice requirements, FAQs, essential information for employers about properly filing and handling lockout notices. What format should the lockout notice use? Employers must use Form 8 when issuing notice to the secretary of every registered trade union connected to the establishment. This standardized form ensures all necessary information is properly documented and legally compliant. All sections of the form must be completed thoroughly. Who needs to receive copies of the lockout notice? Employers must electronically submit copies to the conciliation officer, Chief Labor Commissioner Central, and the central government. Maintain comprehensive records of all communications, including receipt confirmations where possible. Failure to notify all required parties may render the lockout notice invalid. Where should the lockout notice be displayed? The notice must be prominently displayed on the notice board or electronic board at both the main entrance and in the manager's office. Placement should ensure maximum visibility to all employees. The notice must remain posted throughout the entire lockout process. How much advance notice is required for a lockout? Industrial relations regulations mandate at least 14 days notice before implementing a lockout. This mandatory waiting period facilitates potential negotiations and dispute resolution before the lockout is enacted. What information must be included in the lockout notice? The precise date and time when the lockout will commence. Specific, detailed reasons justifying the lockout action. Clear conditions under which normal operations would resume. Sufficient details to provide employees and unions with a comprehensive understanding of the situation and the employer's stance. What happens after submitting a lockout notice? The conciliation officer may initiate discussions between all parties to attempt dispute resolution. Employers should compile and prepare all supporting documentation to substantiate their position. Be prepared to engage in constructive, good faith negotiations throughout the process. Common questions about strike and lockout notices. What should I do if I receive a strike notice? As an employer receiving a strike notice, you must notify the conciliation officer and Chief Labor Commissioner via email within 5 days. You should also acknowledge receipt to the workers' union and prepare all relevant documentation for potential conciliation discussions. What are my responsibilities when issuing a lockout notice? When issuing a lockout notice as an employer, you must inform the conciliation officer and Chief Labor Commissioner by email within 5 days. Additionally, ensure the notice is prominently displayed at your establishment's main entrance and in the manager's office. What is the time frame for reporting these notices? Both types of notices must be reported within 5 days of receipt or issuance. Non-compliance with this timeline may result in penalties under the applicable labor legislation. What is a proper method for submitting this information? All information must be submitted electronically via email. Your communication should include comprehensive details such as establishment name, notice date, and the specific reasons cited for the strike or lockout. What essential information should these reports contain? Your report must include your establishment's name and address, the date of notice receipt or issuance, the number of workers involved, and a detailed explanation of the reasons for the strike or lockout. Are there mandatory forms required for these notices? Yes. Strike notices must use the designated form provided by labor authorities, while lockout notices must specifically use Form 8 as mandated by industrial relations regulations. Who are the required recipients of these notifications beyond government officials? For lockout notices, you are required to notify the secretary of every registered trade union affiliated with your establishment. For strike notices, ensure all appropriate levels of management are properly informed. What follow-up actions are required after notification? Following proper notification, be prepared to participate in conciliation proceedings if initiated by labor authorities. Maintain transparent communication channels with all stakeholders throughout the dispute resolution process. Retrenchment notice. Frequently asked questions. Essential information for employers regarding worker retrenchment requirements. When do I need to send a retrenchment notice? You must issue a notice when retrenching any worker who has completed at least 1 year of service. This requirement applies to all employers across all industries and company sizes. The Industrial Relations Code mandates this notice to protect workers' rights and ensure transparency. What form should I use for the notice? Use Form 9 specifically designed for retrenchment notifications. Complete all required fields including employee information, retrenchment rationale, and the proposed termination date. Ensure the form is complete and accurate, as incomplete submissions may face rejection and delay the process. Who should receive the retrenchment notice? Submit the notice to both the central government and your regional deputy chief labor commissioner. Provide a copy directly to each affected employee. If applicable, furnish a copy to any registered trade union representing your workforce. How can I send the retrenchment notice? Submit via email, registered post, or speed post to ensure traceable delivery. Maintain delivery confirmations and receipts as compliance evidence for at least 3 years. When submitting electronically, use only the officially designated government email addresses. When should I send a notice? Issue the notice at least 30 days before the intended retrenchment date. This mandatory notice period allows for potential conciliation efforts and proper transition planning. Early notification demonstrates good faith and compliance with labor regulations. What information must be included in the notice? Clearly articulate the specific business reasons necessitating the retrenchment. Detail the compensation package being offered, including severance pay and other benefits. Specify the exact effective date when employment will terminate. Are there penalties for not sending a proper retrenchment notice? Non-compliance may result in significant financial penalties and potential legal action. Improper notification can invalidate the entire retrenchment process, creating greater liability. Affected workers may be legally entitled to reinstatement with back wages or enhanced compensation packages. Frequently asked questions. Reemployment of retrenched workers. Essential guidelines for employers regarding legal obligations to previously retrenched employees. When must employers offer jobs to previously retrenched workers? Employers must prioritize retrenched workers for any new job openings within 1 year of their retrenchment. This applies to positions similar to what the worker previously held or roles they are qualified for. The position cannot be advertised externally until this obligation has been fulfilled. How should employers notify retrenched workers about new job openings? Employers must send notification through registered mail, speed post, and email at least 10 days before the hiring process begins. The notice must specify the job title, responsibilities, qualifications, salary range, and application deadline. All communications must be documented and retained for a minimum of 3 years. What preferential treatment must be given to retrenched workers? Retrenched workers who express interest and meet minimum qualifications must be given preference over external candidates, regardless of whether external applicants possess superior qualifications. This protection is designed to provide job security for workers with previous service to the company. What is the required process when a job vacancy arises? Companies must first identify all workers retrenched within the past year whose skills match the position requirements. Notices must be sent to these individuals as described above. The company must observe the full 10-day response period before considering other candidates. All steps in this process must be thoroughly documented. What is the duration of this re-employment obligation? The obligation applies only to workers retrenched within the previous year. After 1 year from the retrenchment date, employers are no longer legally required to give preference to these former employees. Note that some collective bargaining agreements may extend this time frame, so employers should review any applicable agreements. What records must employers maintain regarding re-employment efforts? Employers must maintain comprehensive records of all communications with retrenched workers about new opportunities. This includes copies of notices, delivery confirmations, responses received, and outcomes of each re-employment offer. These records may be requested during labor inspections or in case of disputes. What are the consequences of non-compliance with re-employment requirements? Non-compliance can result in significant penalties under labor laws, including financial fines, compensation payments to affected workers, or mandatory employment orders. Serious violations may negatively impact the company's compliance rating with labor authorities and damage its reputation. Frequently asked questions. Closure notice. Essential guidelines for industrial establishment closure requirements. What form do I need to submit for closing my industrial establishment? You must submit Form 9 with comprehensive closure details. Ensure all sections are completed with precise information about your establishment and specific, factual reasons justifying the closure. Who should receive my closure notice? Submit the original notice to the central government and forward a copy to your regional Deputy Chief Labor Commissioner Central. Both documents must contain identical information and bear authorized signatures from company leadership. How can I send my closure notice? You may submit via email, registered post, or speed post. For electronic submissions, secure a confirmation receipt. When using postal services, maintain delivery confirmation records for at least 3 years. What information must be included in the closure notice? Your Form 9 must contain complete establishment details including registration information, employee data, financial considerations, and a thorough explanation of closure necessity. All supporting documents should be attached as appendices. How much advance notice must I provide before closure? The law requires submission at least 60 days before the intended closure date. This mandatory period allows authorities to conduct a proper review and provides affected workers adequate preparation time. Do I need to inform my workers about the closure? Yes. You are legally obligated to notify all affected workers. Distribute copies of the notice through registered mail, speed post, and email. Additionally, display the notice prominently at all workplace entrances on physical notice boards or electronic displays. What happens after I submit my closure notice? Following submission, the appropriate government authority will conduct a thorough review of your application. They may grant approval, request supplementary information, schedule an inspection, or deny the closure if it fails to satisfy legal requirements. Are there any penalties for not following proper closure procedures? Yes. Non-compliance with closure procedures can result in severe penalties including substantial fines, legal proceedings, and potential compensation orders. Strict adherence to all regulatory requirements is essential to avoid these consequences.
Common questions about layoff permission. Essential information about the layoff permission application process. What form do I need to use for layoff permission? Submit Form X with a comprehensive explanation of your layoff rationale. Include specific details about your establishment, number of affected workers, and the anticipated duration of the layoff. When should I submit my layoff application? File your application at least 60 days before the intended layoff date. This timeframe allows authorities to thoroughly review your case and make an informed determination. Who should receive my layoff application? Submit the original application to the central government. Provide a duplicate copy to your regional Deputy Chief Labor Commissioner Central. Do I need to inform workers about my layoff application? Yes, distribute copies to all affected workers via email and registered or speed post. This transparency ensures workers can adequately prepare for potential employment changes. Where should I display the layoff notice? Post the notice prominently, at the main entrance on a physical notice board or electronic display. Ensure the notice remains clearly visible throughout the entire review period. Why is layoff permission required? Legal regulations mandate employer permission before implementing layoffs to safeguard worker rights. This process ensures layoffs are conducted fairly, and only when genuinely necessary for business operations. What are the consequences of unauthorized layoffs? Implementing layoffs without proper authorization is unlawful and subject to substantial penalties and fines. Additionally, you may face legal action from affected employees seeking compensation. Can authorities reject my layoff application? Yes. Your application may be denied if authorities determine the layoff is unwarranted or alternative solutions haven't been sufficiently explored. You will receive formal written notification explaining the reasons for any rejection. Common questions about continuing a layoff. Clear answers to your questions about extending layoffs in mines affected by fire, flood, excess gas, or explosions. When do I need to apply for continuing a layoff? You must submit your application within 30 days from the commencement of the layoff. Failure to meet this deadline may result in regulatory penalties and complications with your case. What form should I use? Submit Form X to the central government. Ensure the form is completed in its entirety with all required fields properly addressed. What information must I include? Your application must specify the anticipated duration of the layoff, the number of affected workers, your total workforce size, the commencement date, and comprehensive justification for the extension. Include supporting documentation such as safety inspection reports or professional risk assessments. How should I submit my application? Submit via both electronic channels and physical mail using registered or speed post services. Maintain submission receipts and delivery confirmation for your records. Who else needs a copy? Provide a copy to your Regional Deputy Chief Labor Commissioner, Central. Ensure appropriate worker representatives are also formally notified of your application. Do I need to notify the affected workers? Yes. All affected employees must receive proper notification regarding the continuing layoff application. Display notices prominently throughout the workplace and send individual notifications where feasible. What happens if conditions improve before my approved continuation period ends? If workplace safety conditions improve sufficiently to resume operations before the approved extension period concludes, you must promptly notify authorities and follow the prescribed procedures for early termination of the layoff. Can my application for continuation be rejected? Yes, authorities may reject your application if they determine that hazardous conditions have been sufficiently mitigated or that reasonable alternative arrangements could be implemented for affected workers. What compensation must I provide to workers during the extended layoff period? You must provide compensation in accordance with applicable labor legislation. This typically comprises a designated percentage of regular wages and continuation of essential benefits throughout the extension period. FAQs. Review of layoff permission. Important information about the government review process for layoff permission decisions. Who can request a review of a layoff permission decision? The review may be initiated by the government authority suo moto, or upon application by the employer or any affected worker. This includes individual employees, authorized union representatives, or company management personnel with proper authorization. What is the scope of the review process? The reviewing authority thoroughly examines the previous decision to grant or refuse layoff permission. This comprehensive review includes scrutinizing all submitted documentation, verifying compliance with relevant labor legislation, and evaluating the substantive justification provided for the layoff. What is the timeline for the review process? By law, the review must be concluded within 30 days from the date of the original decision. This strict timeline ensures prompt resolution and certainty for both employers and affected workers. What potential outcomes can result from a review? Following the review, the authority may confirm the original decision, modify certain aspects of it, or completely reverse it. All determinations will be formally communicated to all concerned parties with detailed reasoning. Which form is required to request a review? Submit Form Y for requesting a review of any layoff permission decision. Ensure all sections are completely filled, and all pertinent supporting documents are properly annexed to your application. Is it possible to submit additional evidence during the review? Yes, new evidence or information not available during the initial application can be submitted. Such additional documentation must be filed within 7 days of submitting your review application to ensure proper consideration. Are there any fees associated with requesting a review? No official fee is charged for requesting a review of layoff permission decisions. However, applicants should anticipate potential costs for document preparation, notarization, or legal consultation if such services are utilized. Frequently asked questions. Retrenchment permission. What form do I need to use for retrenchment permission? Form X is required for retrenchment permission applications. Ensure you thoroughly document your justification for the retrenchment, including comprehensive details about affected employees and the specific business circumstances necessitating this action. How do I submit my retrenchment application? Submit your application electronically through the official government portal. Additionally, send copies to all affected workers both electronically and via registered post or speed post to ensure proper notification and documentation. Do I need to display the application publicly? Yes. The application must be prominently displayed on a notice board or electronic display at the main entrance of your workplace. This notice must remain visible throughout the entire application process and should be in languages understood by the majority of your workforce. Who is eligible to apply for retrenchment permission? Only employers or their authorized representatives may apply for retrenchment permission. This includes authorized representatives of companies, firms, or establishments that employ the workers being considered for retrenchment. What information must my application include? Your Form X application must clearly articulate all reasons for the proposed retrenchment, including detailed financial data, current business circumstances, alternatives that were considered, and the specific selection criteria used to identify employees for retrenchment. Is there a mandatory waiting period after application submission? Yes. Following submission, you must await the government's decision before initiating any retrenchment actions. The authority typically has 60 days to respond to your application, during which no retrenchment may be implemented. What are my options if my application is rejected? If your application is rejected, the proposed retrenchment cannot proceed. You may either appeal the decision within the specified timeframe, or submit a revised application that addresses the specific concerns raised in the rejection notice. What compensation must be provided to retrenched workers? If permission is granted, you must provide legally mandated compensation to retrenched workers. This typically includes severance pay equal to 15 days average pay for each completed year of continuous service, or any part thereof exceeding 6 months. Review of retrenchment permission, FAQs. Key questions about the retrenchment permission review process. Who can request a review of retrenchment decisions? The central government may initiate a review independently if it determines further examination is necessary. Employers may request a review if they believe the decision negatively impacts their business operations. Workers or their authorized representatives may seek a review if they believe their rights were not protected or proper procedures were not followed. What is the time frame for requesting a review? All review requests must be submitted within 30 days from the date of the original order. This deadline is strictly enforced, with late applications generally rejected unless exceptional circumstances exist. The 30-day period commences from the date of official communication of the order, not its receipt date. What occurs during the review process? The government conducts a comprehensive examination of the original retrenchment decision. All previously submitted documentation and evidence undergoes thorough reconsideration. Relevant parties may be required to provide supplementary information or clarification. The reviewing authority may consider new relevant evidence when appropriate. Are both approved and rejected permissions subject to review? Yes, the government has the authority to review both approval and rejection orders. Identical review standards and procedures apply regardless of the original decision outcome. Which authority conducts the review? Reviews are typically conducted by an authority higher than the original decision-maker. State governments generally handle reviews of district-level decisions. The central government typically reviews state-level decisions. What potential outcomes result from a review? The reviewing authority may confirm the original decision if deemed appropriate. They may modify specific terms or conditions of the original permission. They may completely reverse the decision upon finding substantive errors or relevant new information. They may return the case for reconsideration with specific guidance. Is the review decision considered final? In most instances, post-review decisions are considered final under administrative law. However, parties retain the right to challenge decisions through judicial proceedings if they believe legal errors occurred. FAQs. Closure permission application. Essential information about applying for permission to close an industrial establishment. How do I apply for closure permission? Submit Form X through the Ministry of Labor and Employment's online portal, at least 90 days before your planned closure date. What information must my application include? Provide clear justification for the closure, including relevant financial statements and supporting documentation. Ensure your application is complete to avoid rejection or processing delays. Do I need to inform my workers about the application? Yes. You must send a copy of your application to worker representatives both electronically and via registered or speed post. This mandatory requirement ensures transparency and provides workers with adequate notice. When should I submit my application? Submit at least 90 days, 3 months before your intended closure date. This mandatory waiting period allows for thorough review and provides sufficient notice to affected workers. Applications submitted late may face penalties or rejection. Is there a specific application form? Yes. You must submit Form X electronically with all required fields completed and properly digitally signed. Physical submissions are not accepted for initial applications. What happens after submission? The appropriate government authority will review your application and may request additional information. You must maintain normal operations during the review period until a decision is reached. Can my application be rejected? Yes, applications may be rejected due to insufficient justification, procedural errors, or if authorities determine the closure would cause undue hardship to workers or the community. Is there an application fee? Yes. A processing fee based on your establishment's size must be paid electronically when submitting your application. FAQs. Review of closure permission. Find answers to frequently asked questions about the government's review process for industrial establishment closure decisions. How can I request a review of a closure permission decision? The central government may initiate a review of its own decision, or employers and workers can request one by submitting a formal application. Your application must clearly outline the grounds for review and include any relevant documentation or evidence not considered in the original decision. Submit all materials to the same authority that issued the initial decision. What occurs during the review process? The government conducts a thorough reassessment of the original decision, which includes examining all previously submitted documents, evaluating new evidence provided with the review request, consulting with stakeholders when necessary, and verifying that all legal procedures were correctly followed during the initial decision-making process. What is the timeline for the review process? Reviews must be completed within 30 days from the date of the original decision. In complex cases requiring additional investigation, this period may be extended by up to 15 days. In such cases, applicants will receive notification of the extension, along with an explanation for the delay. What are the possible outcomes of a review? Following the review, the government may confirm, uphold, modify, partially change, or reverse, completely overturn its original decision regarding closure permission. For modified or reversed decisions, the authority will issue a new order with comprehensive reasoning. This new decision becomes the definitive ruling on the matter. Who is responsible for conducting the review? Reviews are typically conducted by senior officials or a specialized committee, whose members were not involved in the original decision-making process. This approach ensures an objective assessment and maintains the integrity of the review by preventing potential conflicts of interest. Is there a cost associated with requesting a review? There is no administrative fee for requesting a review of a closure permission decision. However, applicants must bear any expenses related to compiling and submitting additional evidence or documentation to support their review request. Can a decision undergo multiple reviews? Typically, each decision is eligible for only one review by the same authority. However, if substantial new evidence emerges that was unavailable during the initial review, authorities may consider a second review in exceptional circumstances. After exhausting administrative review options, parties with continuing concerns may pursue judicial remedies through the appropriate legal channels. Worker Reskilling Fund FAQs. How much must employers pay into the fund? Employers must contribute 15 days of wages for each laid-off worker, calculated based on their final salary, including all allowances and benefits. This payment must be submitted online within 10 days of the layoff. Who manages the Reskilling Fund? The central government oversees the fund through a dedicated committee. Payment details, procedures, and submission guidelines are available on the Ministry of Labor and Employment and Chief Labor Commissioner websites. Regular audits ensure transparency in fund management. How do workers receive the money? The central government transfers funds directly to workers' bank accounts within 45 days of receiving the employer's contribution. Workers must ensure their banking details are current in employment records. For transaction issues, workers can contact their regional labor office. What can workers use this money for? The fund is intended for skill development, including vocational training, certification courses, and educational qualifications that enhance employability. Some training institutes offer specialized programs designed specifically for reskilling fund recipients to help workers transition to new industries or roles. Is there a time limit for using the reskilling fund? While no strict deadline exists, Workers are encouraged to enroll in skill development programs within 6 months of receiving funds to maximize re-employment opportunities. The government provides counseling services to help identify suitable training options. Can employers get any benefits from contributing to the fund? Yes. Contributing employers can claim tax benefits under relevant sections of the Income Tax Act. They also fulfill social responsibility obligations and may receive recognition for supporting workforce development initiatives. What happens if employers fail to contribute to the fund? Non-compliant employers may face penalties, including fines and legal action. The Labor Department conducts regular compliance checks, and workers can report violations through the official grievance portal. Frequently asked questions about compounding offenses. What happens if I haven't been prosecuted yet? An officer will send you a digital notice through the Samadhan portal using Form XI. This notice will detail the alleged violation and proposed compounding amount, delivered to your registered email and mobile number. How long do I have to respond to the notice? You must complete Part 3 of the form and pay the full amount within 15 days of receiving the notice. Failing to meet this deadline may trigger prosecution proceedings. What if my case is already in court? You can apply directly to the court to compound your offense. Submit your application to the presiding judge, expressing your willingness to compound the offense according to the relevant legal provisions. What happens after compounding is complete? If all requirements are met, either no complaint will be filed, if not yet prosecuted, or the court will discharge you and close your case. If already prosecuted, this terminates all proceedings related to the offense. How is the compounding amount calculated? The amount is determined based on the nature and severity of the offense, and whether it's a first-time or repeat violation. The exact calculation method is outlined in Schedule I of the regulations. Can I pay the compounding amount in installments? No. The compounding amount must be paid as a single lump sum through designated payment channels within the specified timeframe. Partial payments are not accepted. Is compounding an admission of guilt? Legally, compounding an offense is not considered an admission of guilt. However, you do waive your right to contest the charges in exchange for an expeditious resolution. Can all types of offenses be compounded? No. Only certain categories of offenses specified under the relevant acts can be compounded. Serious offenses and repeat violations beyond certain limits cannot be resolved through compounding. Protected workers. Frequently asked questions. What is a protected worker? A protected worker is a designated trade union officer who receives special legal recognition from their employer. This status provides them with specific protections while performing their union-related responsibilities. Protected workers are safeguarded against actions that could potentially interfere with or impede their legitimate union duties. When must unions notify employers about protected workers? Registered trade unions must submit the names and official addresses of their officers designated as protected workers to employers by April 30th each year. For newly appointed officers during the year, unions must provide notification to the employer within 15 days of the appointment date. How long does protected worker status last? Protected worker status remains valid for 12 months from the date of employer recognition. To maintain continuous protection, the union must submit renewal notifications to the employer before the existing protection period expires. How quickly must employers respond to union notifications? Employers are required to respond in writing within 15 days, providing their official list of recognized protected workers. If an employer fails to respond within this mandatory timeframe, it may constitute a regulatory violation subject to penalties. What happens if there are multiple unions in one workplace? When multiple unions exist in a single workplace, the total allocation of protected workers is distributed proportionally among these unions, based on their verified membership numbers. This system ensures equitable representation across all officially registered unions in the establishment. What protections do protected workers receive? Protected workers enjoy comprehensive safeguards against dismissal, punitive transfers, demotions, or any adverse actions that could impair their ability to fulfill their union responsibilities. Any disciplinary proceedings against a protected worker require special procedural considerations and justifications. Is there a limit to how many protected workers a workplace can have? Yes, the maximum number of protected workers is regulated based on the total workforce size of the establishment. While the specific calculation formula may vary by jurisdiction, it generally follows a progressive proportional system based on employee headcount. What documentation should protected workers carry? Protected workers should maintain an official copy of their employer recognition letter, union appointment certificate, and any specialized identification cards or documents issued specifically designating their protected worker status for verification purposes. Can protected worker status be revoked? Yes, protected worker status may be revoked if the individual ceases to hold a union officer position or engages in activities that substantially violate the terms of their protection. Employers must follow legally prescribed procedures and provide written justification before revoking this status. Common questions about worker complaints. How do I submit a complaint? Submit your complaint using Form 12 through the online portal or via registered speed post. Include sufficient copies for all parties involved. Your complaint should clearly detail the nature of the dispute, relevant dates, and any previous resolution attempts. Who needs to approve my complaint? Your complaint must be verified by either you or your authorized representative. The presiding official, conciliation officer, or tribunal member will assess whether your complaint meets all legal requirements before proceeding with the case. What is Form 12? Form 12 is the mandatory document for filing worker complaints, requiring your personal details, employer information, dispute description, and the specific relief you're seeking. You can obtain this form from your local labor office or download it from the official government website. Can someone else file a complaint for me? Yes. Your authorized representative can file and verify the complaint on your behalf. To designate a representative, complete Form IV and submit it alongside your complaint documents. Is there a time limit for filing complaints? Yes, most labor complaints must be submitted within 3 months of the incident or dispute. In exceptional cases, authorities may grant extensions if you provide valid justification for the delay. What happens after I submit my complaint? Upon submission, your complaint undergoes review for completeness. If accepted, all parties receive notification, and your case is assigned to a conciliation officer who will schedule initial hearings and commence the dispute resolution process. Do I need to pay any fees to file a complaint? No. Filing labor complaints under the code is generally free of charge. The system is designed to ensure all workers can access the complaint process regardless of their financial situation. Worker representation. Frequently asked questions. Essential information about worker representation in workplace disputes under the Industrial Relations Code. Who can represent me if I'm not in a trade union? Any trade union official operating in your industry, or a fellow worker from the same industry can represent you. Choose someone familiar with relevant labor regulations and workplace policies. How do I authorize someone to represent me? Complete and submit Form IV to the appropriate authority. This official authorization must be properly signed before your representative can act on your behalf in any proceedings. When can my representative assist me? Your representative can assist in all dispute proceedings under the Industrial Relations Code, including conciliation meetings, tribunal hearings, arbitration sessions, and management negotiations. Must I be a union member to get representation? No. The code guarantees all workers equal access to representation regardless of union membership. You maintain the right to choose a representative even if you're not part of a union. What authority does my representative have? Your authorized representative can speak for you, present evidence, make arguments, and negotiate settlements. However, they cannot make final decisions without your consent unless specifically authorized in Form IV. Can I change representatives during ongoing proceedings? Yes. Submit a new Form IV to change your representative at any stage. Notify all relevant parties about this change to prevent confusion or delays. What if I cannot find a representative? If you struggle to find a suitable representative, you can ask the conciliation officer or tribunal for recommendations. Legal aid services may also be available for workers who cannot afford or locate representation. Employer representation FAQs. Frequently asked questions about employer representation in industrial dispute proceedings under the Industrial Relations Code. What if I'm an employer not affiliated with any employer association? You can still secure representation by formally authorizing an individual using Form IV to advocate on your behalf during dispute proceedings. Who is eligible to represent me in dispute proceedings? You may select either an official from any registered employer association in your industry, or another employer operating within the same industrial sector. How do I formally authorize a representative? You must complete and submit Form IV to the appropriate authority. This document establishes the legal authorization required for your representative to participate in official dispute proceedings. What types of proceedings can my representative handle? Your authorized representative can participate in all proceedings related to industrial disputes under the Industrial Relations Code, including conciliation meetings, tribunal hearings, and arbitration sessions. Is there a deadline for appointing a representative? While it's advisable to appoint your representative before proceedings commence, you may submit Form IV at any stage of the dispute resolution process if your circumstances change. Can I change my representative during ongoing proceedings? Yes. You can substitute your representative by submitting a new Form IV that explicitly revokes the previous authorization and designates a new representative. Must I attend proceedings if I have appointed a representative? Having a representative does not automatically exempt you from attendance requirements. You should consult with the presiding officer to determine whether your personal presence is mandatory for specific hearings. Are there restrictions on who can represent me? Your representative must qualify as either an official from a recognized employer association in your industry, or an employer operating within the same industrial sector. Legal professionals may only represent you if they satisfy these industry-specific criteria. Inquiry for offenses. Frequently asked questions. Who conducts the inquiry for offenses? An officer with a minimum rank of Under Secretary to the Government of India conducts the inquiry after receiving a formal complaint. How will I be notified about the inquiry? Upon acceptance of your complaint, the inquiry officer will notify you electronically and publish the notice on the Samadhan portal. The notification will specify when to appear with your supporting documents and witnesses. What happens if I cannot attend the hearing? If you fail to appear, the inquiry officer may proceed in your absence. If you are the complainant and miss 2 consecutive hearings, your complaint may be dismissed. Can I request to postpone a hearing? Yes, postponements are permitted, though limited to a maximum of 3 when requested jointly by both parties. The inquiry officer may also approve your participation via video conference if circumstances warrant it. What documents should I bring to the inquiry? You should present all evidence supporting your case, including written statements, photographic evidence, employment records, and any correspondence relevant to the dispute. Is there a time limit for filing a complaint? Yes, complaints must be submitted within 3 months from the date of the alleged offense. The inquiry officer may grant an extension if you provide a justifiable explanation for the delay. What is the format for submitting my complaint? Complaints must be submitted in writing with your signature. Your submission should clearly detail the nature of the offense, the time and location of occurrence, and all parties involved. Electronic submissions are accepted through the Samadhan portal. Can I bring witnesses to the inquiry? Yes, you may present witnesses with direct knowledge of the matter. Submit a list of potential witnesses to the inquiry officer in advance. The officer retains discretion regarding which witnesses will be permitted to testify. How long does the inquiry process typically take? The inquiry officer aims to conclude proceedings within 60 days from receipt of the complaint, though complex cases may require additional time. You will receive regular status updates through the Samadhan portal. Frequently asked questions about inquiry procedures. Who can appear at the inquiry hearing? Anyone with proper authorization can attend. You must present this authorization during the hearing, including legal representatives, authorized family members, or designated organizational representatives. Prepare authorization documents in advance to prevent delays. What if I want someone else to represent me? Your representative must submit a written statement explaining their request to appear on your behalf. The statement should detail their qualifications, relationship to you, and specific reasons for representation. Submit this request at least 7 days before the scheduled hearing. The inquiry officer will make the final decision. Can the inquiry officer refuse to let someone represent me? Yes. If refused, the officer must document the reasons, which commonly include conflict of interest, insufficient qualifications, or suspected malicious intent. You may appeal this decision through appropriate administrative channels within 14 days of refusal. How can I submit my complaint or documents? You may submit in person during office hours, electronically, or by registered speed post. For electronic submissions, ensure all documents are in PDF format with proper signatures. When submitting in person, bring originals plus photocopies. For postal submissions, keep proof of dispatch for your records. How will I know when my documents were received? For physical documents, the inquiry officer will mark the receipt date. Electronic submissions generate an automated acknowledgement. For postal submissions, you can request delivery confirmation.